Hi, my name is Andrew Scott, and I'm a member of the California Lawyers Association Privacy Law Section. And today I'm joined with another member of our section, Jonathan Fairtlough. Jonathan is an experienced cybersecurity expert with over 20 years of experience in the field. He currently is the managing director of cybersecurity at Kroll, which is a provider of services and digital products related to governance, risk, and transparency. So today, Jonathan and I are going to take an opportunity to have a little discussion. Well, Jonathan's going to do more of the talking. I might ask a couple questions for 15 minutes, and we're going to ask a couple questions for Jonathan about his experience in the field and some of his thoughts on the state of cyber security and privacy together today. So without further ado, Jonathan, why don't you tell us a little bit about what your path was into privacy and security?
Absolutely. And first, Andrew, thank you very much for both the opportunity and for the chance to come talk to everybody here today. My path into cyber, I really started when I was in law school. I completed law school, but while I was studying in law school, I had the opportunity to help build out a network for the law firm that I was working on, and really got some great insights from some of the people working with that. And it got me really interested in some of the law and technological pieces around the use of technology. And from there, I was lucky enough to join the DA's office and work on the O.J. Simpson trial, where I was, the Elmo guy, the person who ran all the exhibits and did some of the early pictorial presentations, graphics, et cetera, which further added to my internal reputation at the DA's office as being a technical person. So a few years after the OJ trial, when the DA's office put together the first high technology analysis and litigation team, I was asked to join. And that gave me an opportunity to really start at what was a very early level of cyber. I first started working cyber cases back in 2000, right at Y2K. And most of these cases, there wasn't any structure for filing, so we had to kind of build the approach and the process. And from there, I was able to work with the DA's office, where it was just two of us, to ultimately grow it to a team of about 12, to grow it into a division. And during my time at the DA's office, I ended up prosecuting roughly around 130 different cases of computer intrusion, data theft, and intellectual property theft. I also was lucky enough to handle the first large data breach, which was the ChoicePoint data breach, right after California had passed its new, what we call the breach notification law now, but at the time was really designed to be an identity theft prevention tool, where you had to notify people if you had data that was accessed about them that wasn't encrypted. ChoicePoint was the first that really had to do that in the state of California. That notice, when it hit, ended up going national and created in a sense the start of this entire movement that so many of us are now focused on here today. So that was my case. I helped put that together and helped build out some of the original responses to it. I stayed with the DA's office after that for another 2 or 3 years, and then transitioned over because I really was interested in cyber and cyber law, but I wanted an opportunity to see if I could work it as a practitioner. And Kroll at that time was just building out its new cyber practice. So in 2013, I moved over to Kroll right when we started to see the waves of cyber attacks and the first existence of cyber insurance. So it's now almost 10 years on from that. We're in a very diverse, privacy-focused world with an incredible infrastructure around cybersecurity, cyber litigation, and cyber insurance. And I've continued to work large-scale engagements, help manage some of the more complex ones for cases, and I often act as someone who helps work with lawyers, counsel, and board members to both manage a breach and to understand how to avoid one happening.
Thanks, Jonathan. You're really an eminent authority in this field, and it's particularly when it comes to security, which is often not always thought of as being connected with privacy. You know, there's a common perspective in privacy that privacy and security operate separately and distinctly from one another, but this is not necessarily true. They are rather closely connected. What would be helpful for privacy professionals or businesses to know about the relationship between privacy and security?
Well, first, I think it's really important to understand that from a compliance perspective, security and the ability to conduct an investigation is just as much a critical part of maintaining the information of constituents as the privacy rules are themselves. But part of the problem is that we often draft privacy rules broadly, and in the way in which we categorize different types of information, it can make it unclear to security practitioners whether or not the types of information they can collect or how it can be used is either covered or governed by these particular rules and how it should be approached. And that can have both a chilling effect on the use of appropriate security tools and can also add to confusion around what can or cannot be done in order to secure networks. And I think part of the key here, and this is what I'd really want particularly privacy practitioners to take away, is there needs to be a constant dialogue between the security practitioners who are looking at applying the modern techniques that are constantly being developed in order to protect systems with the view of managing that with privacy law. But here's the underpinning that I want them to take away. Sometimes the tendency, particularly in privacy law, is to look to try and mitigate the regulatory risk as the primary issue. However, if mitigating the regulatory risk removes a significant security tool, well, you can actually you can restrict yourself into a breach. And I'd like to toss out one example of where this sort of thing is going to start to come into play. And that's really focusing on issues like monitoring, being able to monitor network traffic, being able to review network telemetry. That data is really not personal. It is information that is specific to machine and machine actions. And when filtered properly, can provide an incredible early warning system for sophisticated attack or misuse of systems. Yet, the use of that information, the aggregation of it, is where a lot of the power comes, where you've got the capability to run across multiple log sets and filter and understand issues. Understanding that that's a security tool that, if properly controlled and monitored, will enhance the protections of the data on the network and thus enhance privacy, is the viewpoint that I think privacy professionals need to be looking at and encouraging and advocating for. Now, it doesn't mean that there shouldn't be review of what that data is collecting, the reasons for it, and applying the rigor of a good privacy approach to ensuring that information is collected as necessary and appropriate. But we tend to leave out the needs of security in order to secure the data itself, to maintain the fundamental privacy that is required in our evaluation of what can or cannot be used for data.
Wow, that's really fascinating, Jonathan. What came to my mind was you talked about drafting broad regulations and the kind of, we're kind of a regulatory happy society at the moment, especially with respect to privacy, and here in California. In fact, California has enacted significant regulatory privacy laws like the CCPA and the CPRA, forcing companies to become more regulatory savvy and very privacy focused. Large companies have adjusted to this change very easily, having the financial and employment resources to meet compliance requirements relatively easily. But what about the smaller companies that struggle to comply with those regulations because they have less resources? It would seem that businesses are being asked to be more privacy focused. Shouldn't those businesses be given more tools to be helped?
Absolutely. And let's start out with one critical thing. It is really important and a great idea to be building out detailed requirements for how data should be reviewed, protected, and secured. This is a really good thing. But what we have to think about is the unintended consequences of this shift and ensure that we're providing the resources necessary for people to turn this into the competitive advantage it can be, as opposed to a business weight issue on it. As you outlined, now, I wouldn't necessarily say that the large organizations have easily complied with this. In fact, sometimes the complexity of their systems makes that a significant challenge. But the fact of the matter is that they have the resources and the focus to be able to adapt to and to work within regulatory schema. And they really tend to be the targets of this regulation. The issue, though, is when we draft these rules too broadly and don't provide resources to support SME, small to medium-sized businesses, in their capability to enforce it, We can either create a weak point within the privacy infrastructure by having businesses that are either completely exempt and therefore at risk, or businesses that either simply can't comply or have to engage in additional costs to engage in compliance. So there's a couple things that I really think would be a fantastic approach to this. When we are creating regulatory input around this, we also need to be giving guidance that businesses can rely on and some tools to assist. And this is where we can take advantage of both using multiple nonprofits that are out there that help secure and provide input around cybersecurity, and also endorse frameworks and methodologies that can enable people to follow it. A really good example is to look at the amount of information that was created by the federal government during the initial implementation of HIPAA. You can go on to the Department of Health and Human Services and walk through 7-step guides that tell you as a business how to identify, how to secure, what steps to take, what processes to use. It's critical to, when we are asking businesses to take these steps, that we also provide them the guidance and the support to ensure that Californian businesses both become compliant, but also get the competitive advantage for doing so.
Wow. You know, that's a really great insight again. You got me thinking, when the government creates frameworks, and there's obviously a connection between companies and the government's needs and how to balance and manage those. And then obviously the consumer with their data subject rights. There's always been this tension, I guess, between a company's needs to protect privacy and ensure security and the needs of law enforcement. Do you have any thoughts on what, if any, policies could ease that tension? We've got just a couple of minutes left, and we'd love to hear that.
I think we have a great structure already built in with the attorney-client privilege. The concept that you can run an investigation, particularly one where the investigation is going to be targeted towards findings that are going to need to be interpreted by competent counsel to determine if there's regulatory requirements, breach issues, or notice issues. And being able to have frank and detailed conversations around that so that counsel can get the best information to guide the client is a critical piece to this. However, recently we've seen a series of cases that have been really narrowing the scope of privilege and requiring a very structured form around it. And that, I think, is very much to the detriment of overall security, because anytime that you limit or restrict the communication to counsel, well, you restrict the value and the structure of the advice that's given. And nowhere is this more apparent, in my view, in the relationship with law enforcement. Because the concern is that if you share information with law enforcement, does that impact your privilege? Does the information that you share necessarily become public? And I think that there can be significant advantage to allowing businesses through counsel to be able to share information with law enforcement as a safe harbor for privilege. And the reason why is we want law enforcement agencies to understand the threat vectors. We want them to understand how people are being attacked. It's the only way that they can get enough information to both know where to allocate resources and know how to target to stop organized groups, rings, and the large scale both looting of technology and of money from businesses. But if a business is faced with significant regulatory issues, and releasing that information might complicate their ability to control their report and the information that's presented with it, there's a really difficult choice between working with law enforcement and protecting your own self-interest and the interest of your shareholders. And we shouldn't be asking businesses to be put in that particular conflict. Keep in mind that when information is presented to law enforcement, if it results in a criminal filing, if it results in action, that information will become available and will become public. And that's how it should be. But we need to be much more clear to carve out a specific exemption under the privilege rules for providing information to law enforcement for the purpose of assisting their ability to identify the attackers that have impacted businesses. Once that it becomes clearer, I think you're going to see more information going to law enforcement, a better capability to respond to some of these breaches, and a little bit less of our businesses who have been victimized treated as the bad actors themselves.
Wow. Well, Jonathan, that's about all the time that we have today. And on behalf of the California Lawyers Association, thank you very much for spending your time and providing us with your insights. Please feel free to get involved with the California Lawyers Association, and this video will be available for anyone's access on the website soon. So thank you very much, Jonathan.
Thanks for the opportunity.